let's begin the webinar. Let me go to my show. All right. So once again, welcome to our afternoon webinar, Understanding Your Deed, Estate Planning, and Scams. It's good to see everyone this afternoon. Thank you for taking time out of your busy schedule to be here. You are joining us on one of our regular webinars we do on a regular basis. Thank you. This afternoon, we have special guest speaker joining us. First, let me introduce myself. My name is Angela Cummins. I will be, you know, sort of helping out this afternoon. Our first speaker will be Miss Angela Davidson. She is a program director here at NHS Brooklyn. And we're also joined by Miss Rosemary Cantano Esquire. She's from New York Legal Assistance Group. And Miss Davidson will give a more detailed introduction later in the presentation. But thank you, ladies, for agreeing to host this webinar for us. Now, NHS Brooklyn, we are the host for this webinar. So I just want to say a little thing about what we do here at NHS, who we are, what we do. We are a community-based, HUD-approved, nonprofit housing counseling agency. We were founded in 1982, which was a whole 41 years ago. We continue to have the mission to create and preserve affordable housing. As an agency, we seek to revitalize underserved neighborhoods. NHS Brooklyn emphasizes education, financial assistance, and community leadership. We help residents invest in, preserve, and improve their neighborhoods, their homes, and their future. As an agency, we partner with government and businesses. So we're happy to be joined by one of our partners, New York Legal. And we're also led by local residents and guided by local needs. So these are some of the things about NHS. So those of you who join us for the first time, this is who we are, what we do. Now, as an agency, we do offer some programs and services. So let me go over just a few of them. For homeowners and small landlords, I hope most of you are, thank you again for joining us. We provide homeowner education. So as a homeowner, there are a lot of things you need to know about being a homeowner, how to keep your home, maintain your home. So we provide ongoing education on property taxes, home and flood insurance, and also energy efficiency for the home. We offer home repair financing, or I should say we offer access to home repair financing. So what that means is we can help you, assist you in getting a loan or a grant to pay for the repairs to your home. We offer mortgage counseling in form of foreclosure, intervention, refinancing, and reverse mortgage. So as a homeowner, you might need information on how to maintain your home, refinancing on your home, or getting a reverse mortgage. We also offer landlord training. So as a homeowner or a small landlord, you need to know about becoming a landlord. So if you haven't done this yet, please sign up for a landlord training class. We also offer our small landlords an affordable property management program. This is for those of you who are owners of 2 to 4 unit buildings who are thinking, or maybe, single family also, you're thinking that you would need someone to help you manage your property so you can really get some assistance from us, or should I say, you can depend on us for your service for that service to manage your property. Sorry about that. I get tongue twisted when I talk about property management. Now, for tenants and home buyers, if you're on the line, thank you very much for joining. We offer tenant counseling. That's one-on-one counseling for tenants. Those of you who are looking to, say, remain as a tenant and maybe need assistance doing so. We also offer renters insurance education. Now, we don't sell insurance, but we do know the importance of insurance, and so we offer this education. Please join us when we do offer these webinars. We provide home buyer education for first-time home buyers. And as a first-time home buyer, you need to be educated on the home buying process. So once again, we offer that. And that education, by the way, is primarily an 8 to 10 hour class, after which you will get a certificate. But it's a class, not a webinar. We also provide landlord training for first-time home buyers. So as a first-time home buyer, if you're purchasing a 2 to 4 multifamily home, you need to have landlord training before you close. So we offer that training class. And then for everyone, we provide information on estate planning. So tonight we're covering that topic. We also provide financial education and credit improvement, which is important to everyone. Everyone needs to know about their finances and how to improve on it. We also provide information on disaster and emergency preparedness. And I'm going to say a little bit about that at the end of the webinar. And then we offer a home maintenance training class, and that class is currently being offered. It teaches you how to make small repairs around the house. And that is important because who doesn't need to know how to make repairs? It could save you money, and it also allows you to understand how repairs are done to the house. You know, it helps you to maintain the home. So join us or sign up for the home maintenance training when it becomes available next session. Now, I think that's it for a little bit about what we do here. NHS Brooklyn, we are currently located in 2 locations. One in East Flatbush, we have an office at 2806 Church Avenue, and the other is in Canarsie, 9701 Avenue L. Feel free to visit with us, but do call us first for an appointment. You can reach us at 718-469-4679. If you'd like, you can send us an email at info@nhsbrooklyn.org. But most importantly, we'd like for you to visit our website, which is nhsbrooklyn.org. On our website, you'll find all the information I just talked to you about and more. We always update our information. Please visit our website as often as you can. Okay, Ms. Davison, get ready. So before Ms. Davison comes on to introduce our guest speaker, just a few housekeeping items I'd like for you to remember. Please submit your questions to us in the Q&A, and we would prefer that you do it on an ongoing basis. Don't have to wait until after the speaker is finished, but you can put questions in. I will try to address all questions. We will not be able to address anything live, so we would like for you to write in your questions. This webinar is not being recorded for distribution, so if you can, please take notes. Grab a notebook, grab a pen, and take as much notes as possible. At the end of this webinar, we will be sending you a link to a snapshot survey. We would love for you to complete the survey. It is important for us to get your feedback on who you are so that we can let our funders know that this is an important webinar. So as the slide says, at the end of the webinar, do not log out. Just wait for the webinar to be over and then click on the link to complete the survey. Thank you. So now I'd like to turn this presentation over to Ms. Angela Davison, who will take it from here. Ms. Davison.
Thank you, Ms. Cummins, for that great introduction and for, of course, letting our guests and know about NHS and the work that we do. I'm Angela Davidson, and I'm the program director at NHS, working in foreclosure, refinances, reverse mortgages, anything to do with homes I have touched on. And tonight, as Ms. Cummins said, every month we try to bring a webinar on anything to do with delinquencies in home, issues people might be having. It might not be that you're behind on your mortgage, but you just need some information. And this month we have been having issues with deeds, and we thought that bringing this webinar tonight is really informative, and it's really going to shed a lot of lights on deeds and how they are set up. And people sometimes don't understand deeds. So tonight we have a champion, an advocate, somebody I've been working with since 2008 when the foreclosure crisis became a big issue in our communities. And I have worked with Miss Rosemary Cantano since then. She is not only a champion, but she's an advocate, helping to advance policies and procedures for homeowners who are in delinquency. She fights in the courts and she represents homeowners in the courts. She's an expert, has done a lot of work in the foreclosure field, first-time home buyers, doing a lot work in both areas. So of course, for me, she's an expert. She has been an advisor for me. I go to her with all my issues if I have a question, and she's always accommodating and always have an answer for us. Again, stomping the ground, she's there knocking on doors, just fighting for homeowners. And so tonight, she's going to take us down the path of teaching us about deeds. What are the different types of deeds? How do they affect us when we have a deed going, right? If you're buying a first home and you're here tonight, you're going to hear about different ways to set up your deed. If you're already a homeowner, she's going to talk to us about those. So she's going to talk about various things. If you're a homeowner who is delinquent on a mortgage and has another borrower with you on this deed and things have gone a little bit haywire, she's going to clear the air on those and how to address those things. And so without further ado, I'd love to introduce, to give the floor over to Miss Rosemary Cantano. Thanks, Rosemary. You're still muted, Rosemary.
And now I'm still muted. Okay. It's been what, 3 years now, and I'm still having trouble with this Zoom stuff. So thank you for that lovely introduction. And thank you all for coming on tonight on this, holiday week for this really important subject. So I'm the Associate Director of the Consumer Protection Unit at the New York Legal Assistance Group. We call ourselves NYLAG. It's a long title, but like Angela, I've been doing this work for, over a dozen years. And some things have changed and some things haven't. But one of the reasons why we thought this was such an important topic tonight is we represent clients in the 5 boroughs and in Long Island. And I would say at least a third of the clients that come through our doors now, the homeowner is deceased or the person who is on the mortgage is deceased. And it's really, really hard at that point to back things up. So hopefully tonight we'll give you some tips and some suggestions about what to do from the very beginning, what to do if you're in the middle, and then what to do if you are in that position where mom died 5 years ago and nobody is on the deed. So I'm going to try to share my screen now. So fingers crossed, it worked in practice, that it will work now. Okay. Yes, Angela? Okay. So when you are buying a house, if you are buying a house, whether it's your first time home or it's your 17th house, when you go to your real estate attorney, if they don't ask you, how do you want to own this house, then you have to tell them, right? You have to ask them. Obviously, if you're buying it by yourself, one person, these doesn't matter. But let's say it's, a husband and wife or 2 sisters, or maybe 3 people who inherit a house from mom, and now we have to put the deed in, we're putting the deed into their names. It is very important how it is set up originally. Yes, you can always change a deed, right? You can always 5 years later change the deed. I will give the little asterisk that technically in every mortgage document it says that you cannot change the deed. I've in doing real estate since 97, I've never seen a bank, except for one time in all my years, say, no, we're calling the loan due because you've changed your deed. So, technically you could write to the mortgage company and let them know, but so just, that's the FYI, just to let you know that there is that little sentence in your mortgage contract, which is again why if you're refinancing, for example, and your deed is not correct, the time to fix it is when you're doing that refinancing or when you're doing that modification on the loan. So I'm going to start just with the way that you can go into title. And there are 3 basic ways that you can take your, and when I say real property, I mean, these are all for houses. Co-ops are a little different. And, if anyone has a co-op, you can definitely get in touch with us because there's very different rules for co-ops. And if I have time, I'll touch on them. But I'm pretty sure the majority of this audience are condos or houses. So that's where I'm going to do most of my focus. Okay. So 3 different ways you can join on property. joint tenants with a right of survivorship, and I'm going to go over what each of these are: tenants by the entirety or tenants in common. So I'm going to start with joint tenants with right of survivorship. This is what most people think automatically happens, and it's actually the opposite. Joint tenants with right of survivorship means if John and Mary own a house together equally. When if you say John and Mary as joint tenants with right of survivorship, then if John passes away, the house goes directly to Mary, or directly if there's two owners. You do not have to go to court, right? Nobody has to say that house is going to be distributed in a certain way. You don't need a will to say that house goes to Mary. It happens by what they call operation of law. And you may have to call somebody like me, and I may have to show your mortgage company the law and say, no, this is the way it works. You don't need this other person's signature. But it does keep you from having to go to surrogate's court. Now, surrogate's court is the court that when someone passes away and their property needs to be distributed, you have to someone has to start a case. If there is a will, it's called a probate proceeding. If there's no will, it's called an administration proceeding. But it is a costly and slow process. So when you start, if Mary and John don't own it as joint tenants, if they do own it as joint tenants, they can avoid that. And I'll talk a little bit more about surrogate's court when we get to the part where it's going to be more pertinent. But a very important thing here is that you can avoid having to do that. It has to be specifically written on the deed. It has to say John and Mary as joint tenants or as joint tenants with right of survivorship. It's never just assumed. A little different than the next one we're going to talk about, which is tenants by the entirety. It is the same as joint tenants. It's exactly what I just talked about before, except the parties have to be legally married. And then if you get divorced, it gets converted. But if you are legally married at the time you buy the house, then it will be assumed that it is tenants by the entirety, which means that if one spouse dies, it will go automatically over to the other spouse. It should be written on the deed, even though it is by operation of law. It's always a good idea. This way, everyone knows that that there is a spouse involved. Excuse me. Now, you must be legally married. We do not have, New York does not have common law marriage. So even if you've been with someone for 20 years living in the same house, if one of you is only on the deed, the other person is not going to have any rights to that house. So, and this is where I'm going to throw in, throughout this presentation, I'm going to throw in some helpful hints to make your life easier, just from the things that I have seen over all of the years. Be very careful who you put on your deed. Do not just put the person who has better credit. Do not put the cousin you barely know for whatever reason. Certainly do not put the person who knocks on your door and says they're going to do a great job for you they just add them. Once someone is on the deed, you can't unilaterally take them off. You can't decide, you know what, me and Aunt Mary don't talk anymore. I'm taking her off my deed. If she doesn't sign, then you are basically, your house is being held hostage. You can't sell, you can't refinance, you can't modify. You really can't even necessarily defend a foreclosure 100%. So that person can really hold you up, and it can either be someone who just disappears because, people move around, things happen. We've seen a lot of times where two people get a mortgage together. They're both supposed to pay 50%. One stops paying, which means that now they ruin the credit of both people. So now they're not speaking. So one person just disappears. Obviously somebody could pass away, or they can sell their portion of the house to anybody, to an investor, to a tenant, to anybody under the sun. They can sell their part of that house. So it is really important that you are careful about who goes onto the deed of your home. Okay. But just like the joint tenants, you don't have to go to surrogate's court and open an estate. It goes outside of the estate. We're going to talk about some of the things you should do to help keep the house going when someone passes, again, to try to keep it so that if you go to surrogates court, it's going to take you probably at least 6 months to a year to get what you need to actually do something. So we're going to talk about some ways to set things up so that you don't fall into that trap. Okay. The third type is tenants in common. And this is what, if you put nothing on your deed and you're not legally married, this is what is assumed. This is what legally it says happens. What that means is upon death of an owner, title does not go to the other owner. So if Mary and John own a house together as tenants in common, if Mary passes away and Mary has 2 kids, her 2 kids are going to inherit her half of the house. Okay. Even if John's been paying all the bills and John has lived there the whole time, and maybe Mary's even nowhere to be seen, it is still going to be inherited by her heirs. If you don't, so sorry, my throat gets a little dry. So you can leave your ownership interest in a house to someone in a will. If you do a will, which is basically I advise people to go to an attorney's office. I know you can find a will online and you can fill in some blanks. There are attorneys who do not charge astronomical amounts of money. And if unfortunately we don't offer that service, but there are valid, legitimate attorneys who do that and know exactly what to do. So if you want to leave your house to your daughter, we sometimes see people where maybe it's 2 people's second marriage and they buy a house together and they're like, you know what, when each of us dies, we want our children from our first marriage to inherit our half of the house, right? So that's a reason to say, that's a reason to stay tenants and to make yourself tenants in common. But if you are an unmarried couple and you want the house to stay within yourselves and not go to your children, you have to put that joint right of survivorship that we talked about before. Okay. If there is no will, then the law decides how your property is distributed. And there is no changing it. I mean, if you leave someone something, they can turn it down, right? If you leave your half the house to somebody and they don't want it, they can say, no, I don't want it. And then it'll go to the next person. And we're going to talk a little bit about who gets the house if there's no will. But this is something you're going to have to go to the surrogates court. You're going to have to file a petition. If you are a homeowner, the filing is very expensive because the way the surrogates court looks at it is they look at the amount of your assets. So let's say you have a $700,000 house. They don't look at the fact that you have a $500,000 mortgage and say, oh, you have to pay on $200,000 when you do the filing fees, because there's a chart. You have this many assets, you pay this much in filing fees. They look at the whole $700,000. So it is very rare for a homeowner to not have to pay at least $1,000 to file this lawsuit. And in a lot of cases, you may hire an attorney to do it. So it's a pricey thing to do. You might have to do it because there may be other assets and other things that you need to take care of. But if you do, but if you have the house, and then the court is going to have to say, because no one is going to be able to sign or do anything for that house while the person is deceased. Okay, so if Mary's half of the house is out there, if nobody files a court case in surrogates court, then basically the servicer is not even going to talk to Mary's heirs. They're going to say, who are you? Because nobody's basically, when you go to court, surrogates court, someone is put in the place of the deceased person so they can make the decisions. But we've had trouble where the bank won't even talk to us to tell us how much is owed. And we see this with a lot of seniors. Sometimes a lot of senior citizens, one spouse dies, they handled all the finances, and now we're trying to figure out what exactly is owed on the home, and no one will talk to us. And we're going to talk a little bit later on about what you could do before that to just set it up to at least try to go over a couple of these hurdles. Okay, this just gives you an idea of what happens if you own a house and you pass away. And this is even if you're a single homeowner. If, Fred owns a house and Fred passes away and he has no will. If you are legally married and you have no children, the house then just goes to your spouse. That's the simplest way under the law. However, if you are legally married and you have children, your spouse gets half the house, and then all your children inherit the other half. So if you have 4 children, they would each get a quarter of a half, which is maybe an eighth. I can't do that kind of math in my head. Children is natural or adopted children. So if you've legally adopted someone, then but if it is, if two people get married and, the husband, let's say, has a 4-year-old and, mom, she raises him the entire life, he still is not a legal heir. So if she passes away, whatnot, it will not go to him unless she puts it in a will. So very important, if you do have children that you haven't legally adopted, but you consider your own, it's another really important reason to have a will. Okay. If you're not legally married, then all the children just share it equally. If there's no spouse and no children, next in line is your parents. If there's no parents, I believe next it goes to siblings. It goes down a long list of people. If they can't find anybody, if nobody comes forward, eventually the state will come in and take the house. So it is good to know, if you have, if you are someone who has absolutely, for whatever reason, you have nobody you want to leave this house to, then you know what you should do? You can do a will and leave it to a charity. You can do a will and, leave it to a land bank. You can do something so that it doesn't end up going. And I apologize if any of you work for the state or anything here, but it keeps the house basically from being given back. And then nobody gets to really enjoy the proceeds of it. One other thing that you can do with your deed is you can do a life estate deed. So what life estate is a life estate says, okay, I am going to transfer my house to somebody. I'm 85 years old. I, want to give this house to my daughter for whatever reason. Maybe it's because she's the daughter who's taking care of you your whole life, and you want to make sure she gets the house. Or, you want to keep it from, creditors for whatever reason. What you can do is you can do a life estate. And what that says is that you give your daughter the house and she is the legal owner of the house, but she can never throw you out, basically. You have the right to live in that home until you pass away. And now, obviously, it is every family figures out their own way to do this and, how it works. But if you are somebody, I've had a couple cases where the relationship was contentious between mom and daughter. And mom was really worried that daughter would throw her out if she put her name on the house. So, that was a safety net for mom. In most cases, it's just really to make it so that if mom passes away, then, they don't have to do it. You don't have to do anything new to the deed, anything like that. The life estate just disappear. It's as if it was never there. Okay. But the person with the life estate is going to be involved in major decisions with that house. So if you want to sell or refinance or even modify, I believe, that home, that person with the life estate is going to have to sign. So just something to keep in mind, that that person is still going to be involved. Okay. So some of the reasons why, you might want to change the ownership. One, we've talked a lot about the surrogates court. It's expensive. It's slow. You want your home to go to the person or people you want. But, this is where like all the big warning lights come on, especially if you're living in a neighborhood where property values are going up. The amount of scammers, the amount of people who are out there to take advantage of you, you would not believe. So, you really do. Sometimes it's hard, but sometimes you have to take a deep breath and say no to some people. I know sometimes they're really nice and they seem really good. And maybe you're really, really mad at your daughter right now. And you're like, you know what? I don't want her to have this house because I'm really, really mad at her. And this guy is really nice and he comes and he visits and he brings me donuts. So you know what? I'm going to let him. He told me he'll take care of her. I don't have to worry about anything. Okay. No. It is almost impossible to unwind these things. It could be years in court. And in most cases, the foreclosure doesn't stop if there's a mortgage and no one's paying it. Because sometimes what they do is they buy these houses and they don't pay the loans, or they lie to the bank and they tell them that it's a short sale and now they're having you sign documents that turn out to be fraudulent, and now you have a problem. So please, if you If someone is giving you an attorney, if someone is telling you, don't worry, you don't need an attorney, if someone is saying, I'll meet you on the front steps. Good. Angela, you look like you want to say something. You know, and
No,
be
I'm
careful.
just smiling at what you're saying.
Yeah, I mean, and be careful. I have people all the time to say, but we met at the community center. We met at church. He wouldn't do that to me. I'll tell you a story. Before I worked at NILAG, I was a real estate attorney. And there were mortgage brokers that used to join 6 churches or 6 synagogues. And they would spend their entire weekends going to services to meet people to get them into horrible loans. So I'm not telling you to distrust everyone in your church. I'm just saying that, you need to keep your eyes open, and you need to talk to an attorney, or you can go to NHS, right? They can discuss, they're very good at seeing red flags, and then they can, either help you themselves or get them through to a partner like me. So that is the number one thing. You don't sign. If someone's asking you to sign and saying, oh, this is just an application, this is just a real estate listing, and you're not sure, you've never seen this before, don't sign it. Show it to somebody. We've had a lot of people who think they're signing for a refinance and in reality sign their deed over. Somebody gives you a big group of papers to sign and you have never seen them before. You don't know what you're going to get yourself into. Other reasons to change ownership at one point is nursing home liens. So if your father gets sick and he has to go to a nursing home and the state pays for it, the state will attach a lien to that property for all the monies that he would have paid had he paid the nursing home. There is a look back. I think it's 7 years now. So you can't change the deed 6 months before you think he's going to go into a nursing home. So, but if someone is ill, or if your parents are elderly or whatnot, you might want to think about sooner rather than later. Talk to an estate planner or something to see what the best way to do. You can also put the house in a trust. I'm not a trust expert, but there are trusts that prevent nursing homes and things like that. A trust does not get you out of the mortgage. Just as an FYI, when you have a mortgage, your mortgage is on the house. So it doesn't matter how you change the deed. It doesn't matter who you put on the deed. If there is a mortgage on the house, that lien is on the home and they are going to foreclose on it. And it doesn't matter who the owner is. So if the only owner of the house is nowhere to be seen, it's going to be a very easy foreclosure for the bank because you're not even going to have the right to defend it. So, when you're transferring these properties too, one thing very important to know, if you're coming off the deed, right? If you say, well, I'm going to sign for my sister because she needs me to sign in the beginning, but it's no problem. She's got terrible credit. I have good credit. But you know what? In a year, we'll just take me off the deed and then I don't have to worry about it. If she doesn't pay, she doesn't pay. No, because even if you don't own the house anymore, you still are responsible for the loan, which means that even if you sign over the other half to your sister, if your sister doesn't pay, you are responsible for the entire mortgage. So if she's got no money, no job, nothing, and you have a job and you have some savings and you have another house, they are going to get a judgment for the entire thing against you. And they can garnish your salary, they can take your bank accounts, they can take your income, when you file your taxes and you get back your refund. They can take your refund and they can put a lien on your own property. So even if you have your own house and you've been paying the mortgage and all is good, if sister doesn't pay that loan and there's a deficiency, they will put a lien on your home. So be very, very careful about this is my next public announcement. Please be very, very careful about signing for people. I know it is really hard when someone comes and says, oh, this is my dream house and I really need it. I have 3 kids, but I don't have enough income or credit on my own. So can you please, please, please co-sign for me? Co-signing is the same as signing. I mean, they put that little co in front of it, but honestly, there's no difference legally if that loan doesn't get paid. One of the other reasons why you got to be careful about putting people on your deed. I've seen people who put someone on their deed, and then when they need to do something with the house, the person says, well, if you give me $20,000, I'll take my name off the deed. That's not illegal. I mean, that's their asset. So this just goes again to, be really, really careful about what you put on your home. If there are judgments and liens and things like that that somehow got attached to your home, feel free to, reach out to NHS, or when you can have our contact information, reach out to us as well. We can help you with those. Sometimes they're not proper. Sometimes they can be negotiated down. So, same thing if you have, water, taxes, anything like that you're falling behind on, or you're getting questionable bills, feel free to reach out to us, so that we can see what we can do. It is really important, and it is really hard to deal with these kinds of things, but it is really important to deal with them quickly. The worst thing you can do is what they call the ostrich head in the sand, right? It's not going to go away. Okay. The letters are horrible, and, and the phone calls, and you don't have to pick up every single phone call that they make to you, but it's not going to go away. So, it is so much easier when someone comes to me when they're first having a problem, or someone comes to me when, maybe they first get a court case. It is so much easier to help them than if they come to me 2 years into the foreclosure, or dad died 5 years ago and we were paying the mortgage for a while and now we can't, and now no one will even talk to us. So, this is we're, Angela and I, our organizations are part of a larger network, the HOP network of attorneys and housing counselors. So there are people out there to help you for free. We do not charge you anything. Okay. Couple little helpful hints that I wanted, to put out here. When you pass away, anything that is just in your name, bank accounts, stocks, IRAs, they are frozen. You cannot get to them until you get what we talked about earlier, which was the letters testamentary or the letters of administration, which means that it could be 6 months to a year before you can take money out of the account. So if mom has a bank account in just her name, and that's where, she has, let's say, 6 months of reserves to pay the mortgage in case something happens to her, you won't be able to get to that for a while. And it can be longer. If you file to be the person who handles the estate and somebody, let's say your sibling, says, no, I want it to be me, that could take longer if you fight it out in the court. When you go to surrogate's court, one person applies, all the heirs have to sign off. And if they don't sign off on that person handling the estate, then it's a contested matter. And then the surrogate gets involved. So I always say, if you have a family member that you really trust, the person you think is going to take care of the house. Let's say you and your daughter live in the house together, and always lived in the house together, right? And the money goes, open a joint account. You don't have to put all your money in there, but you can put monies in so that when something happens to you, they will have access to that account. We see a lot of sad cases where people go and they can't get to the funds for the burial, right? So it really is important to have some money that somebody else can get into, assuming you have someone that you really, trust to do, and it's always hard for me because it's like, you're always, as a lawyer, I'm always like, no, you don't want to add people and do things and this and that. But the truth is we all need help at times and things can happen. I know 30-year-old people who've been incapacitated from accidents and things of that nature. So it's not pleasant, but it is something that we have to think about. And especially when you have an asset that is worth $5, $6, $7, $8, $900,000 and more. Trust me, if God forbid something happens to you, the scammers will be like piranhas, and they don't wait for the grieving to end. So it is really important. If you have money for, the electric bill, all of those different things, they don't stop being owed the day you pass away. So it's good if you do have money for those bills to have somebody there. You can also send something to your lender if you have a mortgage, authorizing someone else to speak about the mortgage for them. And you have to do this while you're alive, obviously. But this way, honestly, if something happens to you and your daughter calls 2 weeks and her name is on the account, they're probably not even going to know at that point that you're deceased. So, and it's always good to have, if you have someone you trust, to, help out with things like that too, because they won't talk to me as an attorney. Right. So it is. And if you are in a situation where you need more help, or there's more things you need to be done, you can also do a power of attorney. And we do those for clients. I mean, I use a lot when I do these discussions because most of the clients we see are parents to children that are in this, but it can be for anybody. You know, if you're somebody who travels a lot for work, or you're somebody who, you know, you're in the military or something like that, it's always good to have somebody at the very least who's authorized. I'm not telling you all to run out and give people power of attorneys, but if things are going to need to get done, it is not a legal defense to say I wasn't there to do it, or, you know, you know, well, we're collecting the money to go to court. All of those things are not legal defenses. So, you know, but so there's little things that you can do to try to set it up. Now, one thing I do want to throw out there, to let people know when we're talking about adding children to their parents' deeds. The one thing that can be affected by that is you will lose the senior tax exemption. So if you have you know, if your mom's taxes are being cut by 50% because of the, you know, senior exemption, when you put yourself on the deed, that will go away. So then it really does become a balancing act for you to figure out which one is that, you know, is it more important that you don't pay, let's say, the $1,000 on the taxes, or is it more important that, you know, you don't need to go to surrogate's court? That is something that, you know, you have to take into account. But in that case, I would say if you can't, because of the tax exemption, then absolutely do a will, because even though you'll have to go to court, you won't have the problems of people. And I will say sometimes people pop up, someone passes away, and then, you know, so a son they never knew they had for 40 years pops up, and you know what? He's a legal heir. Like, being in the person's life, unfortunately, doesn't have any bearing. So, you know, if you have that brother who nobody has seen in 20 years, still inherits. And now I will say, let's say there's 4 children. If a child predeceases, meaning if the son dies before mom, then his interest is extinguished. He doesn't have an interest anymore. But if mom dies and then he dies, his children, or whoever his heirs are, do step into his shoes. So he's not, you know, his part is not forgotten about. So if you say, well, my sibling is deceased, so we're going to share the house 3 ways now that mom died, you know, it's not necessarily the case. So again, it's you know, you need to talk to someone, kind of have a family tree idea in mind. Okay. So back to the beginning. So there is, as I mentioned briefly, that you can put your home in a trust, which can protect it in certain ways from things. I am not a trust expert. I would highly advise, if you want to do something like that, you go to an attorney who does that, because it can be very tricky, and I don't know the tax consequences and things like that. You know, there's also ways to, if you're on public benefits of any sort, you have to be careful how you do things also, because you don't want to do something that could trigger your benefits to be canceled. So definitely, you know, if you're doing any of this and you are on public benefits, or you think you're going to need to go on public benefits, there is a way to put your home in, I believe it's called a constructive trust, where you don't have to lose the home, but certain monies come out. But that, again, is also a very complicated procedure, and you would really need to go to an attorney who does that. Okay, so I'm going to breathe for a minute. And Angela, if you have any questions that came in, or
Okay.
do you want...
Thank you, Rosemary. We do have a lot of questions, but before we get to questions, one type of deed that we see a lot of, and I'm just asking you to talk a bit about that, and, you know, when do you mostly see that? And it's the quitclaim deed. And is there a difference between quitclaim and a regular deed?
So there's not a huge difference. So a quitclaim deed basically says, I don't know what I own in this house, but whatever I do, it's yours. Right? It protects you if somebody comes back and says, well, wait a minute, well, who's this other person? If you give someone a bargain and sale deed, which is the other type of deed, you're making more of a claim that, you know I am giving you a legal portion of this house, or I'm giving you this house legally. But by operation of law, there's no real difference. Banks always say quitclaim deeds because I think other states have different rules. And keep in mind, I mean, I'm imagining almost everyone here is either Brooklyn or Queens, but every state is different. So all these things I'm talking to you about, if you go buy a house in Jersey, is different.
And then the other thing I want you to talk about, and I hope, it's not one of the questions that's there, is, earlier you spoke about people who sell a portion of their deed. If I sell a portion of my deed, how does that affect my home and the person who bought the deed? What type of rights do they have and what can they do?
So if you sell, let's say you and I own a house together, and you sell your portion to Mr. Smith. Me and Mr. Smith now own that house exactly the same as you did. He steps into your shoes. So what we see with a lot of when people pass away and there is nothing goes on with surrogate court, what we are seeing is these investors are going to relatives and saying, hey, I'll give you $5,000 for your portion of the house. And people don't know, or people just like quick money or whatnot, and they sell it to them. And then, so now ABC Corp or BDF LLC now owns half your house. If two people own a house together, obviously they both need to sign to sell. However, if one person says, no, I won't sell, and one person says, well, I want to sell, the person who wants to sell can go to court and bring what's called a partition action. And the court will order the house sold and the proceeds distributed. There is no way to prevent that, because any owner of a home can, now it's a long process. You got to go to court. It takes a few years. They'll either agree that you're going to list it with a realtor, or the court will put it up at auction. And then in that thing, the judge will decide who gets what if you can't agree to it. But they will force you to sell the house. So be very, very, if your mom passed, and I will say this, almost nobody who knocks on your door and says, let me give you $5,000 for mom's portion of the house is anywhere near what mom's portion of the house is worth. But yeah, but basically that corporate company is now half owner of that home.
And so they have the rights to own a half of the house for $5,000 that's worth $1 million. That's just so unfair. So please be mindful when you're signing documents, as Rosemary said, do not sign something you don't know, and do not take money from anyone, right? If they offer to do something, right, Rosemary? Because the law looks at that as you having to understanding that you took this money, you're selling something, right?
Yeah. The law takes a very hard stand that if you signed it, they're assuming you understood it. And saying, I mean, we've even had cases where like the person didn't speak a word of English, and they're like, well, but they signed it. So you do not count on the courts to unwind those things. The general rule is that if you signed it, you're stuck with it.
Okay. Awesome. Thanks, Rosemary. So can you, and one more question, and then I'll go to the Q&A box. We're seeing a lot now when there are modifications that needs to happen on a home. Someone has applied for last minute and modification is what's been offered. However, there were two people on the loan and we have this quick claim situation. No, the banks are saying that no, both people have to sign regardless of the quick claim deed. How do you handle something like that, especially if you don't know where to find that other person?
There's really nothing to do, right? If the for example, the federal FHA rules, that's their rules, right? Both when someone signs on your loan, on your house, on anything like that, I mean, they really, they take you hostage. I mean, to a certain degree, because the bank is going to be like, well, now some banks will allow it, right? Some banks will say, well, just one person has to sign if you have the quick claim deed. But, rules can change any day, right? So maybe right now you can get a Fannie Mae loan and you can modify it this way. That doesn't mean next month it's going to be the same. So, you really do need, if you have someone on the loan that you really don't want there, if there is any way you can refinance it, right, into a brand new loan, that's preferred, because then you can get rid of that person completely, and then, the home is completely yours.
Okay.
And I will throw in there, if you're in a divorce, you can't just do things because the divorce court has to okay everything. So just to keep in mind that, you know, if you're in a current divorce or even thinking about getting divorced, there are equitable distribution rules and things like that. So keep that in mind.
Okay. So reach out if you have any questions. One other thing though, let me just clarify. Rosemary, I'll ask you to clarify. Somebody who has a life estate deed, if they have a deed, but a daughter or a son want to add them to the deed, if they do it as a life estate deed, they get to keep the tax exemptions, right?
Not if there's any, I don't believe so. Not if there's anyone on that deed that is under 62, but I would have to.
I think
'Cause
with
even
life estate,
there's there may be
it's
some special
considered,
rules.
yeah, it's considered that the senior is the person
Yeah.
who has the life estate, and so they will allow you the tax exemptions
Yeah.
for those kind of deeds. All right. All right, let's get to the questions. I know there's a lot that you went over, so let's get started. All right, so I think you spoke about how can you put your home in a trust, and that is something that you said an attorney is needed for. Can you take that question here tonight?
So I do not have the expertise in
Right.
putting together those trusts, but there are different types of trusts depending on what it is that you're trying to accomplish.
Okay. Okay, so I don't think that other question. Okay, so the person who's going to sell their home and is looking for resources, please contact NHS Brooklyn with that question. It's another deed into trust. Okay, this is a good one. What rights do the children of the co-borrower of a single multi? I'm not sure how single and multi work together, but a single multi-family home who has passed away and divorced his wife, whom he has kids with, and no written will is left. The ex-wife's name or the children are not on the deed. So, okay, I think what the person is asking are what do the rights of somebody who died, who has since remarried, what rights do those children who are not with that new wife have? That person died and didn't leave a will.
Okay. So first things, the ex-wife has no rights in the court. Once you're legally divorced, the ex-wife has no right to come in and demand any part of the house. If the person gets remarried, their spouse is now their spouse. So it would be the new spouse would get half, and then the other half would go to the children. Unless there was a will that was done that says that, you know, upon his death, the house goes to the children, and the deed was done as tenants in common. Because if you're a joint tenant for deed, you can't in your will then say, I want the house to go to my kids, right? So the deed is going. If I could put in my will that I want to leave Angela $5 million. Well, when I die, I can guarantee you got to take off a whole lot of zeros. So Angela can't say no. I have to get $5 million, right? If you leave something in a will you don't own, it's just as if it's not there. And that's what would happen if you were joint tenants. So if two people are getting together for, and they're getting married, it's a second marriage, and you have people in your life from, that you want to give that your half of the house to, you have to set it up as tenants in common. You can also on your deed do percentages, just to let people know. It doesn't have to be 50-50. If one person does a lot of stuff at the house, lives there, whatever, that you can do 75-25. Now, if you're getting a mortgage, you have to talk to your mortgage company and make sure that they don't have any issues with it. But just when you're doing a deed, I could say, you know what, I want to give 10% of my house to my niece for her graduation gift, right? I can do that, but it has to be written out on the deed.
Awesome, thank you. And this person wants to take a deed out of their name and I guess put it into an entity like maybe an LLC or something else. I'm not sure. How do they do that?
So what we have to do, and we can help if it's residential, we can help with that too. Basically, first you have to form the entity, right? So if you, we order from the state and you have to become ABC Corp. I highly advise before you do anything like that, that you talk to an accountant and make sure, any liabilities and all of that with, taxation and filing and all that kind of stuff. And then we just do a regular deed. We just do the deed from Mr. Jones into Jones Incorporated, and everything gets filed.
Awesome. Thank you. And I know you answered this a few minutes ago about this information being specific to New York City and New York State, but it's not applicable nationwide, right? Different states have different laws.
Correct.
as it
Every
pertains
state has
to-
different real estate rules.
Okay.
Most of them are kind of similar, but you never want to do anything in a different state, in a state, especially if it's a state you're not you're not used to, without talking to someone who practices in that area, not someone on the internet who says I do everything on 50 states. You want to talk to somebody locally.
Okay. And anything happens in New York City as it pertains to deed is for the entire New York State, not just New York City or New York or upstate as we're thinking
Correct.
about.
It's
New
the
York
whole
State.
state.
Right. And this other question has to do with, is tenants by entirety assumed even if you're legally married, but have been separated for a while and live apart?
Yes. You could have an estranged husband for 30 years and he's going to get the house and not your grandchildren. So you need to, and you cannot in New York State completely disinherit your spouse. So even if you haven't seen him in 25 years, he's going to get half of everything. So it's a reason you may want to think about filing for divorce. Now he could say, I don't care. I haven't, he could sign off on it. And you can always say, well, I don't want what you're leaving me, but I wouldn't count on that, especially if we have an asset with a lot of money in it. It's amazing how the person you haven't seen in 25 years shows up when there's a couple $100,000.
Right. That's true. That's true. Is it all right? So one of the things we didn't touch on was the tax basis, right? Which was a little bit more involved. But somebody's asking, is it better to leave my house in a will to my children or in a trust so they do not have to take on the same taxes? And I think they're talking about the step-up basis.
I am not an accountant. That is something you really should ask. You need to ask a CPA.
Okay, awesome. And I think the same answer for this one. I have 2 children. What is the best way to leave the home for my children with the least expense involved? The deed is in my name only.
Yeah. I mean, from a legal standpoint, right? The easiest way is to put your children's, if you're comfortable with it, name on the house with you now. But financially, having to do with the taxes and having to do with gift taxes and all of those kinds of things, that is an accountant question.
Okay.
I should have taken more accounting in
I know, right? Okay. And this is another trust question. I think we said speak to an attorney if you need to create a trust, right? Okay. And someone wanted to know, by children, does it mean minor versus adult children?
It's all children.
Doesn't matter, right?
If your child is a minor, then someone will be appointed a guardian for them, and any monies that came out, let's say the house was sold and there's $100,000 a child, money would be put in trust for them.
Okay, so with guardian, I know the court makes that decision. Can you leave a minor child, but then you would leave someone to be an executor for them, or how does that work?
You can put in your will that you want your sister to be the guardian of your minor child. And then usually the surrogate's court will make, if they feel that if I trusted my sister enough to take in my child, that I trust my sister enough to get any monies. So usually it becomes that person.
Thank you. Okay. All right. So my sister and I inherited our home from our father. We're both married. My sister has a child and I do not. My spouse has a child. I want to leave my half of the house to my niece. What do I need to do to ensure my niece receives it?
So you make sure that you own it as tenants in common, and then you do a will leaving your half to your niece. Now your husband can complain. He can go into court and say, I want some of this. I like to think that a lot of times with family they won't, but that's the way to set it up.
Okay. Okay, great question. In the event of a life estate, must the prior owner sign off for anything where the house is offered as collateral?
Yes, refinance, modification, anything that involves the house. Now, not the electric bill or, who's going to collect the trash or whatnot, but for selling, refinancing, anything major, they're going to have to be involved.
Okay. Can a life estate ownership be given to two persons, two people?
Yes.
Yes. Okay. Okay. Good. Great question, right? How can you tell the type of deed you have?
So in the very first part of the deed, it is going to say John Smith and Mary Jones as sellers, right? If it says nothing after that, you are tenants in common. If it says nothing after that and you're married, you're tenants by the entirety. If you see the words joint tenants with right of survivorship, or sometimes it'll say JTROS, then you are joint tenants. Okay. If you have a deed and you have a question about it, feel free to reach out to us. We can certainly go over and explain it to you and see what needs to be done. We're funded by the AG's office to help homeowners.
Yes.
So, please use our services.
Absolutely. Do please reach out. The person who had the question about leaving the home to the niece has another piece to the question, which saying that the deed still has the father's name on there.
So there are different.
It has all three people's name on there, the dad, the sister, and that person's name. So the person wants to know if something happens to her, what happens to the house?
So right now, the estate of dad's heirs own his third of the house, assuming it's not a joint tenant deed, assuming that it was a tenants in common deed. If it's a joint tenants deed, then the other two owners, you now own it, no problems. But if it was a tenants in common deed, his heirs are now step into his shoes. Depending on how long ago he passed away and some other factors, if you're looking to do something like sell the house or refinance out, you can do we can sometimes do what's called an heir at law deed, but that means that all of dad's heirs have to sign off. So let's say dad had 3 sons, all 3 sons are going to have to sign in order to transfer that interest. But you can do if like his other 3 heirs, let's say that there's 3 people in the house and 2 of them are dad's heirs, but there's another brother, right? We can do a new deed where brother will just sign it off to those 2. But that any heirs of dad who would inherit if they went to court has to sign off on it. But it is doable.
Okay, great. So you lead me to a question that I have. So if there are 4 people, say mom has 4 children, mom has passed, and there is still a mortgage on the home, and they want to take over that mortgage, so one person is willing to take on the burden of that. Do they have to go through surrogate's court, or there's a document if they're all in agreement that they can sign without them having to go through probate?
Usually, if you are looking to refinance or you are looking to do something new with the house, the mortgage companies are going to require that you have letters of administration or something for that. Though I will say COVID has changed things. And since COVID, banks have been a little less fussy with certain, like, for example, these heir at law deeds I was talking to you about, there used to be a time where if the person wasn't dead for 3 years, don't even ask. But now, because it's so, I hate to say busy at the surrogate's court, we're able to do it for people who are less. So if they want, so I wouldn't say it's not doable, but it is definitely the kind of, but see, these questions definitely point to the fact that when you have a situation like this, you need to talk to an attorney, right? This is why you don't print forms off the internet and fill things in. Because if you have that one missing brother, he can come back 20 years from now and make everybody's life impossible.
Okay, gotcha. The other question is, sorry, I got away from where I was. Okay, somebody wanted to know about, I think thinking about Medicaid planning. Can you use a life estate deed to assist in that when you're planning for, somebody who needs to get help with Medicaid, but they own a home?
I've seen public benefits attorneys use them. I don't know enough about that, so you would want to speak to somebody who does that. But yes, an attorney who does estate planning will know all, everything from the tax consequences to the, across the board. So that's really somebody that you need to talk to.
Okay.
Not my expertise, unfortunately.
Sorry. And we do have another set of attorneys who come on and talk about estate planning, and they go a little bit more in depth than Rosemary tonight because, it's part of what they do. And so you probably want to check back in for when we're having that set of attorneys on for estate planning again. Suppose someone leaves a property to their 3 children who hold the value equally. Is it possible for any one of them to do anything, refinance, use the house as a collateral, sell their interests without the express consent of the others?
You can sell your interest.
Yes.
You can't get a bank loan. So like you can't go and get a mortgage out from Chase because Chase will not give you. The way that mortgages look at it is everybody has the entire mortgage for the entire house, right? That's why, sometimes you'll see two people own a house together, but only one will be signing the note, but yet 2 of them sign a mortgage. And the reason is because, we always talk about, Chase is giving me a mortgage. In reality, legally, I am giving a mortgage to Chase in the house.
Yes.
So I am the one that's bringing on, who's bringing in the men. The note is just the personal liability. And the difference there is if me and Angela own a house together and I'm the only one on the note and we decide not to pay it, if we owe $500,000 and that house is only worth $400,000, the bank can get what's called a deficiency judgment for $100,000. I signed the note so they can come after me personally. They can take my bank account. They can garnish my salary. They can't do that to Angela. However, they don't just foreclose on my half the house. They take the whole house. And that's why Angela has to sign the mortgage, which is really the security agreement. I always tell people the mortgage is like the pink slip to your house. It basically is the ownership. It basically is giving the bank the right to take it.
Okay. And I think this answers that question. Will the bank allow someone to be on the deed that is not on the mortgage? We've seen that so many times. Yeah. And that's a yes, and it's a no. So what's the real answer, Rosemary? Will the bank allow it?
I mean, the banks normally do allow it. The banks get upset if the person gets taken off, that they, if they used your income and your credit to give them the loan, they're not going to be happy if you're gone. Yes. But honestly, they want your check every month. They don't really care about your deed.
Thank you.
And if something ever happened and they say you added someone to your deed and you can't do that, then you know what? We take them off.
Okay.
So
the other question is, my mom's house, this is terrible. I'm so sorry to hear this. My mom's house was sold by my nephew while she had dementia before she passed. Is there something that I can do now?
Those deed theft cases, those are what I consider real deed theft cases. That is something that you should have an attorney look at. Like that's someone that you should get in touch with Angela, and then she will refer you out to a hot partner to do a deep dive to see what we can do. I'm not gonna lie to you, they are very hard cases to prove. Very, very hard cases to prove, but attorneys will look through them to see if there's anything we can possibly do.
Okay, and somebody wanted to know where to go to get a copy of their deed. And although I know the acronym, I can't remember. I know it's automated, whatever, but yes. It's called ACRIS.
Online, ACRIS, ACRIS. Just Google
automated
ACRIS,
recorded system, something.
Just do some simple account. One helpful tip I'm going to tell people that actually everyone who's a homeowner should do. You should go on ACRIS and you should register. There is a program where you put in your information, and then anytime anything is filed against your property, you will get a notification. So if someone does a phony deed, if somebody puts a lien, and it has been something that has really helped us with the deed theft cases, because you will get a notice that day that somebody put a mortgage on your house or that somebody filed a deed. And I believe you go online, I think it's just a couple questions on the online forum, and then you're in the system. I'll give you an example. We did an event like a year or two ago, and a woman came and she was all upset. She's like, somebody stole my house, and because she got a notification that there was a new deed. Well, her neighbor sold their house and they put the wrong section, block, and lot, right? But
Wow.
she got notified, so we were able to correct it right away. So it is, we only got it passed, they only started doing it about 2 years ago, but I highly recommend everyone to do it.
Yeah, but I think now though I think it's automatic. Once you own a home, anything happens, they send it to you. You don't even have to register anymore. But take Rosemary's advice and register anyway. Right?
Yeah.
So I think the person is asking if the person in the surrogate court would be the executor of the estate.
They're called the executor if there's a will. If there's
Will.
no will, they're called an administrator. But they're basically the one who has the right to make decisions.
Right. If they're the ones who have gone to sign the documents, right? And then
they're the ones who open a bank account. They have the right to pay bills. They have to do an accounting.
Well, let me ask a question on that, Rosemary. If there is more than one heirs, can just anyone go to the courts? Don't they have to get permission from the others to become the administrator of the estate?
So anyone can go and file it, but all the other heirs are going to have to sign something saying they approve.
Okay, gotcha.
If two heirs both want to be, you can have co-administrators.
Yeah.
And there is a way that, the court will ask you, do you want it so that one of you can do things without the other? Or we see a lot of them where maybe the two siblings don't get along or for whatever reason, and they're both co-administrators, which means they both sign off on anything. So you definitely can set it up that way.
Okay. And then this has to do with a bank account. Does the beneficiary on a bank account have access to funds, or does it have to be a joint owner?
There are special beneficiary bank accounts also, but banks have different rules on their different accounts. So you should talk to your bank.
Okay.
And ask them straight out, like, will this be available right away? It should be. If it's an official beneficiary account, it should be. But every bank has their own little tweaks to their accounts. So you definitely should, ask the question right out. If this person passes away on Monday, when can I get to those funds?
Okay. Somebody's asking for a recommendation to create a trust, but I don't. Are you comfortable giving out recommendations?
I don't, because none of the nonprofits do it.
Yeah, we don't.
So it's the private bar. You can always call, the Brooklyn Bar Association and ask for a referral. But unfortunately, I don't have if I did, I would let you. I don't have a good referral.
Yeah, thanks. And somebody wanted to know the name of the trust you mentioned about people on public assistance.
It's a constructive trust.
Constructive trust.
Basically, from what I understand, the house, let's say the house is sold, the money goes in the trust, or it's refied and there's extra monies or whatever, but they don't hold it against you. They'll give you money for your expenses. It's a very complicated thing, but it's called a constructive trust.
Okay, thank you. This question is, can I do a quitclaim deed to leave my portion of the house? Oh, I inherited to my sister. Yeah.
Yeah, you can do a quitclaim deed to anybody you want and give away your portion.
Oh, I don't know how deep you can go into this, Rosemary. Can you explain the recent legislation that was enacted by Governor Hochul regarding deed theft? Or can you talk about some provisions of it? If you can tonight, that's fine. I think we're going to have it up soon.
Yeah, really quickly, a few things that, was, the legislation we've been wanting for a long time. So it's been great. And it gives us some more teeth in court to try to do things. It also makes it easier so for example, I have a client who we actually, the deed theft people were actually all incarcerated and everything. And it's been like 2 years to get the deed back in her name. And one of the things this law does is it allows the DA to put the deeds back in their name. So it's going to hopefully give us some more and I think it goes into effect January 1st. So hopefully it'll give us some more teeth.
Yeah, and we love
but-
that, and we thank the governor for that. But there's also another part to that, and we need to get teeth behind that. Is when the deed is stolen, you give the deed back, but then the home is in foreclosure, or they have taken out all the equity. So that is legislation that I need us to take on again, and fight for that, because that's just still bad business. You've lost your home, you've lost all the equity. You have the house back, but what's the point? There's no equity, and you're in foreclosure. So still need help with that. What if two people own a house, just friends? One passes away, and the children of the person who passed away wants to sell, but you don't want to sell. Will you be forced to?
They can go to court and start a partition action and force you to sell, unfortunately.
Yeah, unfortunately. Okay. My spouse had MLTC Medicaid spent down via a pooled trust account. He passed away. Does Medicaid recover money spent for MLTC from spouse assets, like from our home?
Unfortunately, I have no idea. I don't even know what all those acronyms mean.
The whole spend down.
I will say, though, I mean, organizations like mine, NILAG, and other not-for-profit, we have public benefits departments. Like, we have people that specialize in that. So, Angela, you can always refer people to NILAG's general.
Okay, the general line. Okay,
yeah.
Great. Thank you. Oh, somebody's sharing some information with us, and I thank you so much. It might be worth mentioning, and Rosemary, you can speak to it once I read it out. It might be worth mentioning that there is some protection under the Uniform Partition of Heirs Property Act that New York adopted as RPA and P993. You familiar with it?
Yes. What it means is that now the heirs get settlement conferences, for example.
Okay.
So the heirs get to come into court and be involved. You will not be able to stop the partition, but like when we represent people in partitions, it's to make sure you get your fair share, right? So if you've paid for your taxes and your water, we make sure that you're not getting gypped out, and to make sure that the deed is the right people are there. Because like we had one recently we spoke to where they're insisting, the investors are insisting that they have 40% of the house. And when we did a family tree, we only came up with the person they bought it from had 8% of the house. So there's definitely like all these protections now, whereas before these cases used to just fly by because the investors would just hire an attorney and do them. So now we have the same kind of settlement conferences like we do for mortgages. And that's been really helpful.
Awesome. All right, and we're getting down to the end as we need to wrap up. And this is a great question, and it's something that I would love if this could happen, because while if something happens to your deed, it triggers a notification to you, it only happens after the fact. So this person wanted to know, can I lock my deed? I guess like you lock your credit. So if changes are made, it would trigger a warning to me. That's awesome. I love this question. Can the person lock their deed, Rosemary?
Right to the city council. That's council's purview.
Yes, I love that. Yes, something we definitely need to fight for. Okay, I did speak about that. Who can you speak to? Okay, start a trust. I think we answered those. If your name as a child, okay. If your name as a child is also on the deed, does it make sense to create a trust to avoid capital gain taxes? That tax question again.
That's an accountant's question.
Right. Secondly, if you are on the will, if you're in the will, does that preempt any other sibling that is not in the will any claim to the property?
Yes. If you have 5 kids and you want to leave the house just to your daughter, you can do that. The only person you can't completely write out of your estate is your spouse. But you could decide you want to give one child nothing. You could decide you want to give different things to different children, but you have to do it in a will.
You have to say it in will, right? Because one of the other webinars that we did was that, yes, you can do that, but then your other children can come and challenge the will.
Yes, but they can't challenge that mom should have given it to me because I'm her kid. They have to say mom didn't know what she was doing. The challenge has got to be that mom with dementia or mom was somehow scammed. But you have the right to leave. You can you can disinherit all your children. You could say, I don't like any of my children, I'm giving it to my neighbor. Like, you can do that. It has to be in a will. There's no, as I said, the only person you can't completely write out is a spouse, a legally married spouse.
Thank you, Rosemary. That's awesome to know. My friend and I bought a house almost 30 years ago. My friend passed away a couple of years ago, but he has 2 kids. Do these kids have the right to the house if it's not a common deed?
If it's not a joint tenants deed, yes.
Okay. If the home was owned, or if the home was owned by 3 people and transferred to one of the daughter because it was going to foreclosure, do all 3 have to sign if she has to refinance? So I guess the house is in foreclosure, but I guess one person is willing to refinance it. I don't know how you can refinance a house that's in foreclosure, but they're saying, will the other 3 people have to sign for the refinance to happen?
So what you can do, if the lender allows, so a lot of this is lender rules. But we used to do a lot of what were called deed transfer refis, which meant that somebody who was not on that old loan got a new mortgage to pay off the old loan. And then the only thing that the other people have to sign would be the deed, putting it into that person's house, that person's name, but then, and then the new mortgage would just be in the name of the person who took it out. But banks have gotten very tight with those kinds of things. So it really, the first thing you need to do before you go playing around, if you're doing something with your deed to refinance, I always say, make sure you know exactly what the bank will accept, because you don't want to go through all this craziness, change the deed, and then you can't refinance anyway. And now you've done maybe something you didn't want to do. So
someone wants to know, does citizenship matter if one person is a citizen, the other isn't when it comes to a deed?
No, I mean, you can buy a home as long as you're legally in the US. So, you can, if you have a green card, for example, you can certainly buy a home.
Do you have to pay to get a certified copy of the deed?
No. That is one of the biggest scams out there. The people who mail you stuff and say, give me $200 and I'll get you a certified copy of your deed. You should have your original deed. Your original deed gets, so when you record a deed, they mail it back. Now, they mail the original to whoever I, as the attorney, put on the record and return to. I always put the client, because I feel like you should have your deed. But I will say there is a thought in attorneys, and maybe not so much anymore, but older attorneys like me, that if you have the deed come back to them, then you're going to think that you need them when you go to sell the house. So if you had a real estate attorney, they may have your original deed, but there is absolutely nothing you need your original deed for. And there is almost nothing you're going to need a certified copy of a deed. The only time you're ever going to need a certified copy of a deed is probably if you're involved in a court case. So just a photocopy of the deed, it's registered. As long as it's on ACRIS, you're golden. By the way, if you go on ACRIS and your deed is not there, or you can't find it, you should get in touch with us, because things did have, especially when real estate was booming, things get lost and things like that. So
good. Thanks for that information, Rosemary. Would a will or estate plan be good if you're leaving your 3-family home, I guess, to your 3 grands equally to ensure they get it?
I mean, a will is the way to ensure that your property goes exactly where you want it to go. I mean, if you don't have a spouse and you only have 3 children, that is, but who knows what happened? Maybe somebody will get married. If you really want your everything to go to a specific place, like if you have an engagement ring that you absolutely want a specific door to have, if you have, anything that you have a car that you want your son to have, you got to put it in a will. If, unless you do something beforehand. Unfortunately, I know people who had to go to surrogate court just for the car. Yes. So, no.
Okay, and we're run out of time. If I don't get to all the questions tonight, we will definitely try to get them answered, because it's a lot that's left and we're already at 7:28. But here's a good one. If you gave someone power of attorney, can they refinance your house? Can they sell your house without your knowledge?
Yes. Now, most title companies will want to talk to you. Well, but the truth is, it's very easy to put someone on the other side of the phone. So a title company might throw something here and there, but yes, when you give someone a power of attorney over your real estate, they can basically do everything to that house that you can do. Power of attorney literally steps into your shoes.
Okay. Is this true? Somebody was saying this is true for co-op owners, but I don't know what is true for co-op owners. So
So
if you can rewrite,
yeah,
an idea?
real quick. Co-ops are personal property.
Yeah.
So instead of a mortgage or instead of a deed, you get a stock certificate. Some boards will let you put joint ownership on the stock certificate. Some boards won't. That's up to your board. But your stock is considered the same way as like your car or your bank account. It's personal property.
Yeah. All right. So for the people who need help, you can reach out to us. Rosemary's going to have her information at the end. Some people want to know, how they can get help, I guess, setting up like with Medicaid and stuff to spend down those things that your office can also help them with. Somebody wanted to know if you can have an agreement, a contract, so that the co-owner on the property cannot sell unless it's agreed to together.
People try to do things like that,
Yeah.
but they don't tend to stand up.
Okay.
Because you'd have to sue them for breach of contract, and it's a messy way to do it.
Right.
Now, if you think it's the kind of thing that if you do, you feel that they will live up to it, but it's going to be a battle. If they fight it, it's going to be a battle.
Okay. Awesome. Thank you. And Mr. Farrell,
Okay.
thank you for sharing some information with us. We appreciate your assistance in sharing some information on different things. He gave us the full name of ACRIS. Trying to find it again. Automated City Register. Can never remember that off the top of my head.
Just type in
Automated City Register Information System, ACRIS.
Yeah. Just type in ACRIS and
Yes.
you'll get right there on Google or whatever.
All right.
engine you-
Rosemary, thank you so much. So
All
I'm going
right.
to turn it
So
back
much
over
for
to Miss
inviting me.
Angela Cummins to close us out for the night. Thank you, Mom. I'm sorry for going over so far into the evening.
All right, thank you very much, Rosemary. That was really good information. Sure, I mean, with the amount of questions we have means, people have a lot of questions and very eager. So as Ms. Davidson said, if you have additional question, you didn't get a chance for your question to be answered, you can shoot us an email tomorrow and we will try to respond to you. But let me move on. I'm gonna redo my share. So I want to thank Ms. Angela Davidson. Angela Davidson is Program Director at NHS Brooklyn. Thank you very much. The other person you'll be reaching out to, particularly the one for all these questions about trust and estate plan and all that, Ms. Davidson. Now, if you want to reach Ms. Rosemary Cantano, Rosemary, I do remember I changed your information earlier, and then this one doesn't have it. So let me go back because I know the first one has it. Just want to share your information with the group that if someone wants to reach out, yeah, I know, I forgot. Okay, so if you want to reach out to Rosemary, you can reach her at rmcantano@nylag.org, or you can call her directly at 212-613-6568. That's her direct number. But we do suggest that you reach out to Ms. Angela Davidson, and she will make the referral to Ms. Cantano and anyone else that you may need assistance from. But Rosemary, thank you, and we're looking forward to seeing you again. I'm sure our visitors and participants are also looking forward to having a repeat of this workshop. Thank you very much.
One shout out, Ms. Cummins, before you go. I was just informed that the Farrell person who has been answering some of the questions tonight is the DA from the DA's office. So we really want to thank the DA's office for being on here with us tonight. I didn't. I recognize the name Farrell. I just couldn't remember that it was him. Thanks so much.
Thank you.
For your right support and partnership all the time.
Exactly. We don't do it all by ourselves. That's why NHS, we partner with government. Thank you very much, partner. Now, and also want to thank everyone for joining us. You did take time out of your schedule this afternoon to be with us. Rosemary did mention that it is a holiday week. So we thank you for joining. We did have a lot of people. And we're actually looking forward to seeing you again. And also want to thank our other colleagues for joining and helping to answer questions. Now, I just want to remind you, everyone, that NHS Brooklyn, we do have other webinars, other workshops, and other services that we provide to the community. So I want to remind you of them. These are upcoming events for the rest of the month and in December. We'll be doing our first-time homebuyer orientation next Tuesday at 12 p.m. So if you're a first-time homebuyer or you're just interested in knowing about the home buying process, please join us next Tuesday. For those of you who are current landlords or you're looking to purchase multifamily home, you can attend our landlord training. It is a fee for it, but you must register online. Now, everyone needs to know about insurance. And so we do have an insurance webinar coming up, home insurance on Thursday, next week, Thursday, I'm sorry, and also one on December 6th. So it says or. So please visit our website. We will have the correct date on there. And other webinars, we have financial coaching, which we'll be doing on December 6th. We didn't do one for November, so if you thought you missed it, you didn't. We reschedule for December. So please join us. Now, some of this information is important, especially you're thinking about the estate planning. You might be thinking, great to have a home, but finance is also important to know about before you embark on some of these decisions. So please attend our financial coaching and credit improvement webinar. And our energy efficiency and strategies resources, that's for homeowners, but in particular, how to make your home more energy efficient, how to save on some of your energy bills. Please also register for that webinar on December 7th. And again, other insurance webinars are coming up. So please register for them. Okay, Ms. Davidson mentioned she'll be able to put you in contact with other attorneys who provide estate planning in particular. So please reach out to us for free counseling and that we can refer you for free legal help to create the documents. And documents we're referring to are wills, power of attorney, living wills, healthcare proxy. So there is a program out there available. I think I needed to, Ms. Davidson, you forgot to remind me that I need to expand. Okay, so I'm sorry, got carried away. So estate planning, yes, there is a program out there, and NHS Brooklyn is working with other agencies to provide this service. So please give us a call and we will refer you. As we just mentioned, you know, how important a power of attorney is, how important a will is. You need to have those things in place. Please contact us, Ms. Angela Davison, for information for the free legal help. Now, if you are a Brooklyn veteran, you know, were provided service for the U.S. United States, and you are now disabled, and you would need some assistance in getting around in the home, whether it's your own home or maybe it's a rental. You could be a homeowner or a tenant. There are some funds available to make your home more accessible, right? Like including a ramp, a chairlift, or modify the bathroom. You might be eligible for this grant. Please reach out to us. We did say there's some eligibility requirements. Now, if you are eligible for any government assistance, you would most likely be eligible for this program as well. So please do reach out to us for that assistance. Funds are running out. Okay, the word is getting out there, so please reach out to us quickly before they go out. NHS Brooklyn, we want you to be prepared for emergencies and disasters. Now it's not a matter of if an emergency or disaster will happen, but we know it will happen. So please be prepared. And the first thing to do in being prepared is have a plan. Gather your supplies in a go bag. Here we have a picture of a go bag with all the stuff that you should have in there. And remember, this is going to be needed, right? A lot of people are thinking, oh, this may never happen, but you never know. It's an emergency. You don't, you know, plan to have an emergency, but you want to plan in case something happens that you will be ready. So gather your supplies. set a meeting place with your family, get more information. Visit our website for more information. Join our webinars when we have them. Also, get involved with other agencies such as Flood New York, Know Your Zone, Notify NYC, especially Notify NYC, where they have a phone app. You want to have that in case an emergency occurs, you will be notified. So again, please, everyone, be prepared for any emergency and disaster. And we're not only talking about natural disasters, we're talking about also financial disasters. You want to be prepared in case something happens. Okay. NHS Brooklyn has partnered with the NYS Energy Audits, where they're providing a program called Empower. It's funded by NYSERDA. What it does is it provides free weatherization to homeowners to have their home insulated properly. So in the wintertime, your home will remain warm. In the summertime, your home will be cool. It is free for some people, so please give us a call just to see if you are eligible, but it is something that you should take into consideration, right? You might be able to get some free insulation for your walls, some free hair sealing for the doors or windows, or you might even get a free refrigerator replacement. So free for some people. Please give us a call. Now, NHS Brooklyn has joined the Community Support Network. It is a program, a joint program with the Department of Health, just to reach out to individuals in zip codes 11203, 11212, 11226, and 11233. The goal is to reach out to provide you with referrals on different things such as physical health, day-to-day functioning, food insecurity, lack of clothing. Now, NHS Brooklyn, we focus a lot on housing, but we also want you to know that you can rely on us for referrals for anything. The goal is to help you avoid any type of physical or mental health crisis that should occur. So please reach out. We do have a webpage on our website. It's nhsbrooklyn.org/CSN. So please look for that website. Also, you might see some of workers going around talking to people. Indulge us. We just want to check in just to see how you're doing and also make referrals if you need some. Okay. NHS Brooklyn, once again, we are on social media. Please follow us and say hi. We're on Facebook, Instagram, and we're on X or Twitter. So please visit us and say hi. There's lots of information that we do send out through social media. And lastly, I want to thank you once again for joining us. It was a pleasure having everyone. Thank you again, Rosemary. Thank you, Angela Davidson. Thank you also our staff, Kia and Arimia, for attending this webinar. Now, once I log off this webinar, you will receive a link to a snapshot survey. We're asking everyone to please complete this survey. What this does for us is to help us to petition our funders to get more funding and also to let them know that it's an important webinar. So please complete this survey for us. All right, so do not log out at the end of the webinar, just follow the instructions. And we will see you again at the next webinar. So have a wonderful Thanksgiving week, everyone, and we'll see you again next time. Good night.
Thanks, everyone. Thank you. Thank you. Miss Cummings, I'll
Davis.
call you in a few minutes.
No problem.